Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottled Business Show. Welcome to all of our returning viewers. And if you're new to the show, well, you're in for a treat today. We broadcast this show every Tuesday or every other Tuesday here at 10 a.m. You can find us on Twitter, Facebook. Used to find us on Google+, but that doesn't exist anymore. You can find us on LinkedIn. And is there another one, Bill? I can't remember.
Yeah, what is it about Google+, Rick? Why are they Why are they taking off? I mean, that's great.
I just don't think they took off as well as they thought they were. So they're eliminating that from the outline. But, you know, you just Google us on any social media platform. You can find us. And then you can always find us on Bottled Business Sense Show at bottlebusinesssenseshow.com, and a full library of almost 5 years of shows where we offer legal education, marketing education, that sort of thing. So check us out if you're new to the show. If not, buckle in.
Yeah, I want to thank people too, on local business people in the Orange County, LA area, where they're hooking up with our show and with me and I'm assuming with Rick as well, on Alignable, Alignable, I think it is, alignable.com. Yeah. And it's a business site, and our shows are posted there. Not posted there, but they're links there for the shows. And I've been getting a lot of contacts from that particular site. So check that out if you're into expanding your business and connecting with other people.
Yeah, that's great. So today's topic, Bill is going to talk about employers' sexual harassment training obligations under the California law. So with that, we'll jump right into the topic, and I'll hand it off to you, Bill.
Yeah, thanks, Rick. This is important stuff because this really deals with what an employer's obligation is in terms of training their staff. Because let it be known that you can get into serious problems if a claim is made and you haven't trained your staff properly, and you haven't instituted a subsequent policy pursuant to that training properly. So let's start off here and let's just basically talk real quick about the fact that if you have five or more employees under California law, and that would include, by the way, seasonal employees or even temporary employees. If your number comes to at least five, you need to provide at least 2 hours of sexual harassment training. So let's recap this. 2 hours sexual harassment training. And you need to provide it to all supervisors and non-supervisory personnel. The difference being non-supervisors get 1 hour. So 2 hours to all supervisors, 1 hour to the rest of your non-supervisory employees. And that must be done no later than January 1st, 2020. And that's pursuant to a new law in California. And then you must do it every 2 years. After January 1st, 2020, when you've done your initial 2 hours and 1 hour respectively, you need to do it every 2 years thereafter. And the bill does require that the Department of Fair Employment and Housing, which is a California statutory framework, it's called DFEH for short, develops these courses on their website and makes them available to you if you want to take a look at them right now. Also, they comprise informational posters and fact sheets that have all the sexual harassment and actual discrimination laws as well on these, and you must post them in a conspicuous area in appropriate languages that may be applicable to your business if you have people that speak different languages besides English, and you must post those in a conspicuous place. That's required by all employers. Now, I started at the beginning saying employers with 5 or more employees, and that's true, but wouldn't you be somewhat foolish if you have less than 5 employees and you didn't do this? Why wouldn't you do it? What would be, in other words, the only reason you'd give is, well, I don't have to do it. I don't have 5 employees. I'm free and clear. You want to make employees and people that are associated with your business in tune with the applicable laws, not only as to sexual harassment, but with regard to discrimination laws. So I would say to you that it's a very important thing to do, whether you have 5 employees or not. But the law says 5 or more. So from there, let's talk about what the training must cover in general. So when you do this training by January 1st, 2020, 2 hours for supervisors, 1 hour for non-supervisory personnel, you must cover the California Fair Employment Act and Title VII of the Civil Rights Act. So the federal law is encompassed in Title VII, and the state law is encompassed in the California Fair Employment Act, also known as FEHA, F-E-H-A. So the DFEH, which is the Department of Fair Employment and Housing, is incorporated under the California Fair Employment and Housing Act, known as FEHA, F-E-H-A. Very, very simple. It's very straightforward. So you need to cover the topics that are encompassed in those acts, and you need to recover the remedies available for sexual harassment victims. Okay, because this is going to impress upon people what these remedies can be and how they can affect your business long term. You need to cover how to prevent harassment, obviously, and I'm giving you general topics, but this is all encompassed in the videos on DFEH website and on Title VII. And you need to cover the essential elements of an anti-harassment policy and how to utilize them if a complaint's filed. So we're going to get into that in a minute, what the policy is that you should encompass and what steps you take to enforce that policy. So again, cover the California Fair Employment and Housing Act and Title VII discrimination and harassment laws. Cover the remedies that are encompassed in those laws. Cover how to prevent sexual harassment, steps you can take to prevent those things from happening. And cover the essential elements of a harassment policy, what you should include in a policy that you're now going to institute for your company. Those are the general areas of training that you provide your employees. And I would say to you to go to the DFEH or Title VII websites to get a general background on that. Also, you should cover anti-bullying statutes. And you can find anti-bullying statutes addressed as well. Be aware that there's no law that prevents an employer from being rude. But when you start bullying people, and that bullying can have an underlying basis that might be discriminatory or harassing in nature, it just seems very, very wise to do away with it altogether. So that should be encompassed in your training as well. And again, I would go to the DFEH website. That'll be covered there. Before we get into the 10 critical steps that you need to institute in order to have a firm and sound sexual harassment prevention policy in your workplace, let me just mention a couple of things I'm going to go over this real quick. Certain businesses like talent agencies must provide educational materials in a way that might be a little bit different. They need to make these nutrition and eating disorders available. Certain eating disorders and nutrition disorders need to be made available to the people within the agency structure. I mention that because if you deal in that kind of business, you need to investigate that more fully. And then hotel and motel operators need to provide at least 20 minutes of interactive training on human trafficking, because human trafficking in large part encompasses the use of hotels and motels. Dig into that deeper. If you're in those two businesses, it's not really something I'm going to get into in any depth in this show, but I wanted to make you at least aware of it. So now let's get into the anti-harassment policies. Write this down if you can, because this is important. Here's 10 things you need to do. You need to make sure that in developing an anti-harassment, discrimination, and retaliation policy, it must be in writing. That's step number one. Now, you'd think that would be pretty obvious, but it's got to be in writing. Number two, list all current protected categories covered under the Act. So when you review the Fair Employment and Housing Act online or by way of your attorney, make sure that your policy encompasses every one of the categories that is listed in that act. Sexual harassment, age discrimination, medical condition discrimination, those sorts of things. I could go on and name them, but they're all there in the act. That's number two. Number three, make sure coworkers and third parties, as well as supervisors and managers with whom employees come into contact, make sure that the law prohibits engaging in conduct prohibited by the Act. So name these people in your policy. Say, hey, all employees, all supervisors, any third parties who come in contact with anybody in my business are prohibited from entertaining contact that would violate any of those policies. That's number three. Number four, create a complaint process. Number four, create a complaint process. Okay? Make sure you indicate that there's going to be confidentiality and a timely response to any complaint that's made. Make sure you indicate that any complaint is going to be handled by an impartial investigator. Make sure that documentation is provided to track the course of the investigation. Make sure that there are appropriate options in place to be able to remedy any problems that might arise from a complaint before it gets to litigation. And make sure that you have timely closure of this investigation. Don't let it go on forever and ever. Nip it in the bud. So make sure that this complaint process is in writing and is part of your policy. You understand, folks, what we're dealing with here? We're dealing with a policy that you must have in place and the categories that must be addressed within this policy, if you're tuning in a little late. Number five, provide a complaint mechanism that does not require an employee to complain directly to an immediate supervisor. Maybe you have a human resources department. Maybe you have a complaint hotline. Maybe you have an omnibudsman on site. Maybe you just have a method whereby you say, here you go, connect with the Equal Opportunity Employment Commission or the Department of Fair Employment and Housing. The EEOC, Equal Opportunity Employment Commission, is a federal regulatory board, and the Department of Fair Employment and Housing has FEHA, which is a state regulatory board that we've discussed earlier. Maybe you have that in place, but you have something in place and in writing that says to the employee, hey, here's somebody you can make the complaint to. It doesn't have to be your direct supervisor. Number six, instruct supervisors to report any complaints of misconduct to a designated company representative. And we've touched upon that a little bit, but make sure this is in writing. Make sure that the complaint is in writing and that it's designated to the particular person who needs to be aware of it. And make sure that this policy that you have is, again, part of your training. Okay. Number 7, indicate when an employer receives allegations of misconduct, indicate in your policy that there will be a fair, timely, and thorough investigation, and that all parties will receive appropriate due process, a hearing so they can be heard. Make sure you have a second person in the room when an employee complains to you about anything like this. Number 8, emphasize again that confidentiality will be kept to the extent an employer can do so. If it becomes the matter of investigation by a state or federal agency, obviously that ability goes down somewhat. Number 9, indicate that at the end of the investigation, any misconduct that might be found will immediately put in place remedial measures. Here's what we're going to do as a company to make sure this never happens again. You got to have that down. You got to have it in writing. And finally, number 10, make clear that employees shall not be exposed to retaliation. What's retaliation? Well, if you complain about sexual harassment or any any other kind of discrimination, for that matter, you may suffer consequences in the workplace, such as a demotion or refusal to be promoted, a disciplinary action. Those could be considered retaliation. Those need to be made clear that will not occur in your workplace. So these 10 things, folks, need to be in a written policy that you institute in your company after you do the training that we mentioned at the top of the show, which must be completed for 2 hours for supervisory personnel, 1 hour for all non-supervisory personnel by January 1st, 2020, and then every 2 years thereafter, it must be done again. Include in that training the fact that this policy will be instituted, and then institute this policy according to the 10 items I mentioned. If you have the policy instituted already, great. Present it, put it up there on the board, and make it part of the training that we talked about at the top of the show. Critical stuff and really practical stuff that employers need to do to safeguard their business and to make sure their employees are happy and safe. So that's my advice, Rick, and I hope it's taken to heart. I know it's becoming more and more sensitive in the workplace, as it should be, and these are all things that you can find online very easily. Watch our show again if you need to, and then go to the Department of Fair Employment and Housing website, or go to the Equal Opportunity Employment Commission website. There's a lot of materials available to people out there.
Awesome. Well, as always, Bill, thank you very much for the information. Folks, you can always replay this if you want to review what Bill talked about, or go ahead and reach out to him. His contact information is right below this video, and he'd be happy to take up a discussion with you.
And sometimes, Rick and I, we discuss this after we're off the air. And sometimes Rick will have some really interesting questions that come up once we start discussing this. We try, and in a semblance of order, not to take up too much time on this show. But every now and then, Rick will have some really good questions. So Rick, if you put your thinking cap on, and if you do have any right now, let's address them. If not, we'll let everybody go and get about their business. But always feel free to do that, because Rick comes up with some good questions every now and then, especially when we're off air, and when we get to chat about this a little bit, and when I try to help him with his business. One thing I will say real quick: make sure you get a lawyer on board here, please. This is not stuff that is. It's straightforward in a way, but in order to make sure that you're protected long term, get a lawyer on your side to help you with this stuff. Believe me, what you're going to pay a lawyer is well worth the investment when it comes down to comparing it to potential litigation.
Yeah, exactly. I don't have any questions now, but I'm sure I'll probably think of some as soon as we get off the air, like you said.
And know what, Rick? If you do have them, write them down, and we'll institute a new thing in our show that at the beginning of a new show, we'll refer to questions that we did in past shows, or the most recent show, and then we'll address them off the top and say, here's a question we had from our last show, and we'll do it. I think that's a good way to do it.
Yeah, absolutely. Well, as always, Bill, thank you again for your expertise.
You're welcome.
If folks, if you need to talk to Bill a little bit further about this, then reach out to him at the contact information below. So with that, we will sign off here for this episode, and we'll see you again in 2 weeks, where we'll be discussing employer meal policies requiring that employees stay on company premises and discussing about that. So we will see you again on the next episode of the Bottled Business Sense Show, and everyone have a great day.
Take care, everybody.